Hey out there, legal warriors. Pretrial hearings. Man, we get so many questions about pretrial hearings. What is a pretrial hearing? How many pretrial hearings can we have? What's the purpose of it? What am I supposed to do? Well, if you're interested in the criminal law or you're facing a pretrial hearing, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. What is a pretrial hearing? Well, a pretrial hearing for the purposes of this video is a hearing that is scheduled after an arraignment on a criminal charge. So a criminal case has been filed against somebody we call a defendant, at least in adult court, and there's been an arraignment where we enter a plea of not guilty. Now they've set other types of hearings, and they're called different things in different places. For misdemeanors, they're typically called pretrial hearings. For felonies, they might be called an omnibus hearing. But the purpose of a pretrial hearing is to force the parties together. And who are the parties? The prosecutors, the party that represents the state, which is prosecuting the defendant of the crime, and the other party is really the defense attorney who's representing the defendant and defending them against the state. The defendant may have to be present at the pretrial hearing. Post-COVID, there's some rules where sometimes we can waive presence, but the main purpose is to force the attorneys to recognize that a case exists and move the case towards either resolution or trial. And so a pretrial hearing usually has 30 or 40 different cases on it. There's going to be a judge, a court clerk. It may be done by Zoom or it may be done on in person, but the purpose of the hearing is sort of to report to the court in a very a broad way what's going on. And the most common outcome of a pretrial hearing is, Judge, we need a little more time because X, Y, or Z. We need to review discovery, we need to interview witnesses, we need to negotiate, the client needs to do some classes, the prosecutor's not ready to look at it, we are doing some classes and we need more time. So the pretrial hearing, the purpose is to check in. And so the questions we often get is, well, what do I need to do at the pretrial hearing, is what a client might ask. And you might wonder, well, the main thing you need to do is just show up and do what your attorney tells you to do. The most common thing you're going to need to do is acknowledge that you have a right to a speedy trial. We have a right to a trial within 90 days of the date we're arraigned. Usually we don't want a trial because we're trying to resolve the case. And you have to tell the court you understand you have a right to a speedy trial, but by your pretrial getting continued, we're going to extend the deadline we have to get to a trial, which means we're going to waive your speedy trial rights for a period of time. So that's mainly what you're going to have to do at a pretrial hearing, or a defendant is. And so what's the question we get? I mentioned in the opening, well, is there a limit on the number of pretrials? Typically, the court will eventually put its foot down and say, this is the last continuance, no more pretrials. But the secret is usually there can still be another continuance because the court has the same incentive. While the court wants to resolve cases only and limit their caseload that they have to deal with and their staff, still a trial takes a long time. And so if the parties are earnestly working towards a resolution, oftentimes the courts will give a little more leeway. So there is no official limit on the number of pretrials. However, sometimes courts have their own way of doing things, sort of their own culture. They'll try to put a limit on it. Sometimes they will. But think about in your head that there is no official limit in the court rules regarding how many pretrials there can be. So why so many pretrials, right? Why does the case keep getting continued? And I think the main reason that happens is, well, the main good reason it happens is, as time passes, at least for the defense, people that are the wronged parties, the aggrieved parties in the supposed crime, are less mad, right? The sooner we're dealing with a problem, the sooner we're dealing with the shock of it, the sooner in time, then the more shocked we are. Also, as time passes and you stay out of trouble, you're a better risk for the prosecutor to take a chance on being more lenient with you. As time passes, you have a chance to do classes and do things to give the prosecutor a way to respond to the case besides convicting you. And also sometimes there just needs to be a lot of pretrials because the backup in the system has already made it that way, right? Just think about it. Your case is getting charged at some point in time, and when you sort of join this pretrial calendar dance, well, there's already all other types of people on that pretrial calendar too that have older cases. And so the prosecutors focusing usually on resolving those older cases because they know at some point the judge is going to say, no, we need to get those resolved. So when a case is newer, sometimes even the prosecutor isn't sort of programmed in their head to think, well, it's time for me to think about resolving this. They might, but it's instinctively, since we're humans, creatures of instinct, it sort of is less urgent to try to focus on that case because a prosecutor, just like all of us, only has so much executive function, so much decision-making power in a day. And so that's why we see a lot of pretrial hearings. There's good defense strategy oftentimes, and also there's a lot of necessity because the system is quite a bit overwhelmed. As we all know, there's not enough funding for any part of the criminal system. At least I know it because I'm in it. Everyone's opinion can differ, but we're all doing the best we can. So that's why we typically see so many pretrial hearings. And I think the final question I want to cover is, so what happens if we don't get our case resolved at a pretrial hearing? So there's all these pretrial hearings, Lance, and then hopefully we're going to enter a resolution of the case at some pretrial hearing, but what if we can't? Well, then what's the next step? Well, the next step is typically a trial. And for the most part, unless you're in juvenile court where there's no right to a trial by jury, it's going to be a jury trial. And there may be an intervening type of hearing. There could be something they call like a confirmation hearing to make sure it's going to go to trial. That's basically a pretrial by another name. There could be a motion hearing about evidence prior to a trial. But if we can't get it resolved, there's only one possible solution in our system. They won't dismiss, prosecutor won't dismiss it, and we won't plead guilty. Well, that's why we have trials, and that's why we have the jury system. And so then we're going to go to a jury trial. We've got another video about how a jury trial works, right? We have that here on our channel. But basically, at a jury trial, it's totally different. Well, I've said before, at a pre-trial, you're just sort of showing up and saying yes or no to things. At a jury trial, you're going to see witnesses. You're going to see the police officer. There's going to have to be people that the state prosecutor calls as witnesses against you, trying to prove the case that they've brought against you. And then your attorney will have a chance to question those witnesses in front of the jury. And then you'll have a chance to present your own witnesses, and you actually have a chance to testify too. You need to talk to your attorney about that. So what happens if we can't resolve the case after a pretrial? Then there's going to be a trial. So this is pretty in-depth dive to what happens at pretrial hearings, and I hope you found this useful. If so, please like and please subscribe, because more people who have a pretrial hearing will get to see this. And more importantly, if you have a legal problem, feel free to reach out to my firm. Again, my name's Attorney Lance Fryrear. We've been doing this for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.